Welcome to the next in our series of videos from the Wilkes Partnership. I'm Helen Smart, a solicitor in the corporate department, and today I'm with Kevin Lynch, who is the head of our probate litigation team. So Kevin, if you live with someone and you're not married to them, what protection do you have if they pass away and they've failed to make a will?
In short, Helen, the answer is there would be no protection. A lot of people are under the mistaken belief that as, let's say, common law wife or husband, that they have some sort of protection, that they are somehow a beneficiary under a deceased person's estate. They would not be. In that scenario, the individual would die intestate, and under the intestacy rules, that would be the cohabitee, would not be entitled to anything under the deceased estate. They would be protected if they were a co-owner of the property under usual land law principles, but not under the principles in the intestacy rules.
And what's the Inheritance Act, and how could that help someone who's the cohabiting partner?
Yeah, well, as I said, just in the situation of a cohabiting partner, now this is a very common practice within families and within people, that you do not have the more kind of traditional nuclear family, that there is a lot of divergence within that nuclear family, one of which is long-term kind of partners and cohabitees. But the Inheritance Act is designed to protect people exactly like that. So the Inheritance Act is an act of statute which came into effect in 1975 and enables people to argue that they are entitled to a reasonable provision if there are a class of individuals protected under the statute, such as cohabitees or individuals who have been substantively maintained financially by a deceased.
And if you do decide to bring a claim under the Inheritance Act, I understand there are some quite strict time limits under which you need to make those claims.
Yes, the time limits are also set out under the Act, and an individual must bring a claim to the court within 6 months of the grant of probate or letters of administration being granted. The Act does allow a degree of flexibility, and an application can be made at a time. However, I would strongly warn any individual not to do so, because the court would only grant permission in the most limited and exceptional circumstances.
And is it possible just to stay in the house once your partner's passed away and just wait it out, or see if you get evicted? What happens there?
In short, Helen, no. If again in that scenario of a cohabitee, let's say the cohabitee in this scenario doesn't have any interest in the property and has been residing in the partner's house, and that partner has sadly died. In that scenario, the cohabitee had a license to remain in the property during the partner's lifetime. When he died or when she died, that license ended, and the administrators or the executors of an estate could write to the cohabitee requesting that they vacate. On foot of that notice, under land law, they are trespassers at that stage, and an application can be made to the court to remove them as trespassers. However, at the same time, under the Inheritance Act, an individual can claim a reasonable provision, and that reasonable provision can be not just simply money from or a proportion of the estate, but also a right to remain in a property, or indeed an interest in that property. On that basis, an individual could turn around and say that no order for possession should be made while I'm bringing a claim under the Inheritance Act, and that should take precedent over any possession claim. What I would say, Helen, as practical advice to any individual who is in that situation, is to get legal advice quickly, so that their Inheritance Act claim can be assessed, and that any residential need be identified and set out to the executors or administrators of an estate.
And where there is a will and you're someone who's looking to perhaps challenge it, What is a caveat and how can they be used?
Yes, in principle, a caveat is a simple enough type of process. It is a form to be sent into the registrar in order to block the grant of administration or the grant of probate, and preventing the distribution of the deceased assets under the process of administering somebody's estate. Filing a caveat only costs £20, and it is a simple enough process, but there should be warnings put on that. It is not as simple to say that you can just launch a caveat for any reason. You must be only launching a caveat if you are challenging a will or you have concerns regarding the administration of the estate per se. There is a general misconception that if you're bringing an Inheritance Act claim, that you should file a caveat. That is not the case. In relation to the Inheritance Act claim, you are not challenging the will itself. You are merely saying to a court, and indeed to the individual beneficiaries of the estate, that I should have been given a reasonable provision.
And what are the common pitfalls of entering a caveat?
Common pitfalls are anything from launching a caveat and then effectively doing nothing, because once you launch a caveat, it will last in the first instance for 6 months. Individuals do have a habit of thinking 6 months is a very, very long period of time and they can deal with it in 5 months' time. Sadly, in my experience, 6 months can go rather quickly. You can look to extend it, but a caveat is not something you can simply put in and then just go back to work. You should be justifying why the caveat is there. So a classic scenario is that you do have concerns regarding an individual's testamentary capacity. Yes, launch a caveat. It would be a prudent step to do. But you then must go and undertake an investigation to find out whether you have good grounds to challenge the will on the basis of the deceased's lack of testamentary capacity. If you fail to do that, you may find that the individuals administering the deceased estate could start what's called the warning off procedure. That is the procedure to remove a caveat. You can challenge that procedure by way of filing an appearance. But once you file an appearance, that caveat is now permanent, which in turn could lead to a greater dispute and ultimately an application be made to court to remove your caveat.
And Kevin, finally, how has your team been impacted by COVID-19?
Yes, just like everybody else up and down the country, and I dare say the entire world, we are starting to get used to working remotely, which has, without doubt, its challenges. But we have managed to get a process now where our team and the solicitors within my team have been able to work remotely and are able to advise clients and represent them both in court and indeed just on a one-to-one basis as before. So we are certainly learning that the office is not as essential as it once was.
Brilliant. Thanks very much for your time, Kevin. Your contact details will appear at the end of this video, so if you do need to contact Kevin or anyone in this team, then please use those. As Kevin said, we're still working and we're still here, so please feel free to get in contact. Thank you very much.